of clear, cogent, and convincing evidence. The first issue reads as follows. Did defendant make extrajudicial statements to or in the presence of representatives of the news media, including those set forth in paragraphs 12 through 177 of the amended complaint? Yes. 2. Did defendant know or should defendant reasonably have known that his extrajudicial statements set forth in paragraphs 12 through 177 of the amended complaint would be disseminated by means of public communication? Yes. Did defendant know or should defendant reasonably have known that his extrajudicial statements set forth in paragraphs 12 through 177 of the amended complaint would have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter in violation of Rule 3.6a? Yes. 4. Did defendant's extrajudicial statements set forth in paragraphs 12 through 177 of the amended complaint have a substantial likelihood of heightening public condemnation of the accused in violation of Rule 3.8F of the revised Rules of Professional Conduct? Yes. With this further note of explanation, it will be necessary for us to have a finding, I believe, that the accused in this instance includes the set of suspects, that being the lacrosse players that were at the house on the night in question. It is not necessary for us to make a finding as a legal matter that they were actually indicted or criminal defendants at the time. 5. By making misleading statements to or in the presence of representatives of the news media, did defendant engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4c of the revised Rules of Professional Conduct? No. A word of explanation there. The one statement at issue there involving whether or not condoms might be involved is, to our mind, no worse than certain others that were not alleged to involve dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4c. For instance, the statement to the effect that the accused were not cooperating. And since it was not alleged that those statements involved an 8.4c violation, we do not think it is appropriate to pick out this particular one and say that it is, although we have the option as a matter of law of finding some of the other statements to also include a Rule 8.4c violation. We decline to do so. Number 6. Did defendant, by not providing to the Duke defendants prior to November 16, 2006, a complete report setting forth the results of all tests or examinations conducted by DSI, including the potentially exculpatory DNA test results and evidence, A, failed to make timely disclosure to the defense of all evidence or information known to him that tended to negate the guilt of the accused in violation of former Rule 3.8d of the revised Rules of Professional Conduct? Yes. B, cell phones off. B, fail to make a reasonably diligent effort to comply with a legally proper discovery request in violation of former Rule 3.4d of the revised Rules of Professional Conduct? Yes. Did defendant, by not providing to the Duke defendants prior to November 16, 2006 memorializations of Dr. Meehan's oral statements concerning the results of all examinations and tests conducted by DSI in written, recorded, or any other form, A, fail to make timely disclosure to the defense of all evidence or information known to him that tended to negate the guilt of the accused in violation of former Rule 3.8D of the Revised Rules of Professional Conduct. The answer is yes, with the proviso that the way that issue number 7 is worded with the word memorializations tends to imply that the violation is premised on violation of the discovery statute rather than 3.8D. We think for purposes of issue 7A, it may be more appropriate to call that communication in any form of Dr. Meehan's oral statements, and not to say memorializations. B, 7B, fail to make a reasonably diligent effort to comply with a legally proper discovery request in violation of former Rule 3.4D of the Revised Rules of Professional Conduct. That answer is no, based upon the converse of the distinction in A. That is, to the extent that that is based upon compliance with the discovery statute, at the time there was evidence that the Attorney General took the position that prosecutors did not have to provide such memorializations, and therefore there is a plausible reliance by the defendant upon that position at the time, which is no longer the law, of the Attorney General, and that is the basis for saying no to 7B. 8, the defendant, by not providing to the Duke defendants after November 16, 2006, a complete report setting forth the results of all tests or examinations conducted by DSI, including the potentially exculpatory DNA test results and evidence. A, fail after a reasonably diligent inquiry to make timely disclosure to the defense of all evidence or information required to be disclosed by applicable law, rules of procedure, or court opinions, including all evidence or information known to him that tended to negate the guilt of the accused in violation of current Rule 3.8D of the Revised Rules of Professional Conduct. The answer is yes. B, fail to disclose evidence or information that he knew or reasonably should have known was subject to disclosure under applicable law, rules of procedure, or evidence, or court opinions in violation of current Rule 3.4D3 of the Revised Rules of Professional Conduct. The answer is yes. 9, the defendant, not providing to the Duke defendants after November 16, 2006, memorializations of Dr. Meehan's oral statements concerning the results of all examinations and tests conducted by DSI in written, recorded, or any other form. A, fail after a reasonably diligent inquiry to make timely disclosure to the defense of all evidence or information required to be disclosed by applicable law, rules of procedure, or court opinions, including all evidence or information known to him that tended to negate the guilt of the accused in violation of current Rule 3.8D of the Revised Rules of Professional Conduct. The answer is yes. B, fail to disclose evidence or information that he knew or reasonably should have known was subject to disclosure under applicable law, rules of procedure, or evidence, or court opinions in violation of current Rule 3.4D3 of the Revised Rules of Professional Conduct. The answer is yes. Number 10, did defendant, by instructing Dr. Meehan to prepare a report containing positive matches, A, knowingly disobey an obligation under the rules of a tribunal in violation of Rule 3.4C of the revised rules of professional conduct? The answer is yes. B, request a person other than a client to refrain from voluntarily giving relevant information to another party in violation of Rule 3.4F of the revised rules of professional conduct. That answer is no. 11, did defendant, by representing to the court that he had provided all potentially exculpatory evidence, A, make false statements of material fact or law to a tribunal in violation of Rule 3.3A1? The answer is yes. B, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4C of the revised rules of professional conduct? The answer is yes. 12, did defendant, by representing to opposing counsel that he had provided all potentially exculpatory evidence, A, make false statements of material fact to a third person in the course of representing a client in violation of Rule 4.1? The answer is yes. B, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4C of the revised rules of professional conduct? The answer is yes. 13, did defendant, by representing to the court that the substance of all Dr. Meehan's oral statements to him concerning the results of all examinations and tests conducted by DSI were included in DSI's report, A, make false statements of material fact or law to a tribunal in violation of Rule 3.3A1? The answer is yes. B, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4C of the revised rules of professional conduct? The answer is yes. 14, the defendant, by representing to opposing counsel that the substance of all Dr. Meehan's oral statements to him concerning the results of all examinations and tests conducted by DSI were included in DSI's report, A, make false statements of material fact to a third person in the course of representing a client in violation of Rule 4.1? Yes. B, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4C of the revised rules of professional conduct? The answer is yes. 15, the defendant, by representing or implying to the court at the beginning of the December 15, 2006 hearing that he was not aware of the potentially exculpatory DNA results, or alternatively, was not aware of their exclusion from DSI's report, A, make false statements of material fact or law to a tribunal in violation of Rule 3.3A1? The answer is yes. B, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4C of the revised rules of professional conduct? The answer is yes. Did defendant, by representing to the grievance committee of the State Bar that the agreement with Brian Meehan to limit the information in DSI's report was based on privacy concerns of releasing the names and DNA profiles of individuals providing known reference specimens, A, knowingly make a false statement of material fact in connection with a disciplinary matter in violation of Rule 8.1A? The answer is no. B, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4C? The answer is no. 17, did defendant, by representing to the grievance committee of the State Bar that he did not realize that the potentially exculpatory DNA test results were not included in DSI's report when he provided it to the Duke defendants or thereafter, A, knowingly make a false statement of material fact in connection with a disciplinary matter in violation of Rule 8.1a? The answer is yes. B, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4c? The answer is yes. 18, did defendant, by representing to the grievance committee of the State Bar that his statements to the court at the beginning of the December 15 hearing referred not to the existence of the potentially exculpatory DNA test results, but to the Duke defendant's purported allegation that an intentional attempt had been made to conceal such evidence? A, knowingly make false statements of a material fact in connection with a disciplinary matter in violation of Rule 8.1a? The answer is yes. B, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of Rule 8.4c? The answer is yes. Here I wish to note the consensus of the hearing committee in regard to those issues that I've just read involving misrepresentations by the defendant in his response to the grievance committee. We have some concern that those charges, more or less as a matter of policy, are perhaps not warranted from the standpoint that we have concerns that it is very rare that persons are charged with making false statements to the grievance committee in their responses, and that if defendants are charged with that, it may have a chilling effect upon defendants or respondents making a full and complete disclosure to grievance committee complaints if they are afraid that, well, if you just disagree with what I tell you, and that if we go to trial and I lose, then by necessity I have misrepresented something to you, that is perhaps unwise as a matter of policy. Nevertheless, it is alleged here, and we do find that in certain instances there were violations. But we would simply note that in this particular case, it may be, at least in our view, something of an instance of overcharging. 19. Did defendant, through one or more of the above violations, engage in conduct prejudicial to the administration of justice in violation of Rule 8.4d? The answer is yes. At the conclusion of Phase 2, we will provide certain additional reasoning for our findings and overall conclusions, and, of course, as to the discipline imposed. Looking forward to the conclusion of the proceedings, what we will do is, as we normally do, ask counsel for the State Bar to prepare a proposed written order for us and to provide that to the defendant's counsel for their review and submission to us, and of course we may make and probably will make a number of changes to it. I'm saying that now so we don't have to go over that again. At this time, we'll go into Phase 2. I ask the State Bar, do you have additional evidence to present on Phase 2?
Yes, sir. The State Bar will call Jerry Parnell.
All right.
Where your testimony will be recorded. Hopefully, then nothing but the truth to help you God.
I do.
Good afternoon, Mr. Evans.
Good afternoon.
Would you state your full name, please?
My name is David Charles Evans.
And are you the father of David Evans, one of the players, Mr. Nifong, charged?
Yes, our son's name is David Forker Evans, and Forker is my wife's maiden name.
And what is your occupation?
I'm a lawyer.
And what type of law do you practice?
My clients are nonprofit industry, trade associations, and professional societies.
And where do you practice?
Washington, D.C.
What firm?
Reed Smith.
How many lawyers in that firm?
We have about 1,500 lawyers.
And how long have you been practicing law?
I started with Reed Smith in 1971, so I've been practicing for 36 years.
And can you describe just generally your family background?
Yes, I grew up in northern Indiana, Warsaw, Indiana, a small town. My father was a Yellow Page advertising executive. My mother worked in the home. I have an older brother by 14 months that I hope to see tomorrow at a family reunion down in Savannah, Georgia, where my wife is from. And I have two nephews, and Doug and Dave, and Dave has 3 sons. My parents moved to Florida after my father retired in the 80s, and they have both passed away.
And are you married?
Yes, I am. My wife, Ray, is here today with me.
Has she been here throughout these proceedings?
Yes, Ray has been here since Tuesday morning with the opening gavel.
Where did your son grow up, Mr. Evans?
Dave grew up in the Washington, D.C. area. He was born in Washington. We grew up in the Maryland suburbs of Bethesda and Chevy Chase.
And what type of kid was David growing up?
A great kid. Fun, focused, hardworking, athletic, just a great kid.
And describe his interactions with other kids and people when he was growing up.
Dave always has had a lot of friends. I think of Dave as being very inclusive. If there was somebody a little quiet or a little overweight, he always was sure that they were part of the group.
And after high school, he decided to attend Duke.
Yes, he went to school at Landon School in Bethesda. He was recruited for lacrosse at a number of schools, but he narrowed it down to 3, and then he chose Duke.
And did he ultimately end up getting a scholarship at Duke for lacrosse?
Dave was recruited, but he did not go to Duke on a scholarship. He played his freshman and sophomore years without a scholarship. He started his sophomore, junior, and senior years, all the games. So he ended up with a scholarship the second semester of his junior year and the second semester of his senior year, and he earned that through hard work and performance on the field and leadership.
And describe his experience at Duke the first 3 years that he was there.
Dave loves Duke, and he made some of the best friends you could ever make. The young men on the Duke lacrosse team are the finest young men that I've met. He made great friends. He also did well academically, ended up with a 3.4 grade point average, and he made all ACC academic team each year. He also was elected captain in his senior year, which I think is one of his proudest moments. He loves his teammates.
Did he play in the national championship game in 2005 as a member of the lacrosse team?
Yes, he did. He started in that game. Duke lost to Johns Hopkins 9-8 in a thriller.
Your son was one of the class team captains who hosted the party on March 13th.
Yes, that's correct. The captains hosted a party that had been a tradition during spring break for over 15 years.
And after these events, came up, did your son accept any kind of responsibility for that, the decisions that were made?
Dave called me on Friday, the day after the police had begun their investigation and showed up at the house with a search warrant. I remember sitting in my office and getting a call a little after 1 o'clock in the afternoon and seeing on the caller ID Coach Pressler, and picked it up, and it was Dave. And he explained to me the situation, what had happened the night before. The first thing he said was, made a mistake, and we know that, but I want to describe this situation to you. Over the course of the next 10 days to 2 weeks, Dave, with other captains, met with senior officials at Duke. They stepped up to the plate. They apologized for hosting a party and hiring dancers. They then, after meeting with the president of Duke University, prepared a written statement, and in that written statement they accepted responsibility and apologized for the shame that they had brought upon their families and the university.
And this was that for the party itself as opposed to anything else?
For hosting the party and hiring dancers.
And you're aware that the police came and searched the house?
Yes, I am.
And that your son went down and gave us a statement and some other information?
I would like to think that Dave did, and his two roommates at 610 North Buchanan, Matt Zash and Danny Flannery, did exactly what a prosecutor and the police would want. They cooperated fully. They offered to take lie detector tests, which were refused. They told their story. They asked if there was anything else they could do. They offered DNA samples. After giving oral statements for from 5 to 7 hours, they prepared written statements which were shown on this screen. And I can tell you that Dave's written statement was the most detailed, 7 pages, and that the very first night that the police got involved in this investigation, they knew exactly what happened from that statement, because that statement is a carbon copy of the statement, the report that was issued by the Attorney General.
And during the time that your son was in police custody for, I think the record establishes 7+ hours, did he ever try to contact you for any reason?
Dave did not. He was there uncounseled. He had not called either of us, his parents. He actually had been, 2 days before, Dean Sue Waslick of Duke had actually contacted Coach Pressler indicating that there had been some report, and I could get into the details of that, but I think the most important thing is to say that while Dave did not speak with her, Matt and Danny did, that she advised them to cooperate fully and tell the truth if the police came to see them, and they did precisely that, uncounseled and without consulting with parents.
Now, beginning on March 27th, it's been established that Mr. Nifong made statements to the news media concerning the team members' refusal to cooperate or make statements. Are you familiar with some of those statements?
Yes, I am.
And as the father of one of those young men, what was your reaction to those statements?
We were floored. Our son had cooperated fully. The police had told a local paper that the residents at 610 North Buchanan were cooperating fully. It was, we just couldn't figure out why Mr. Nifong was making these statements when in fact it was obvious that the 3 residents of the house had cooperated to the best of their ability.
One of the statements that Mr. Nifong made in this case is he commented to the effect, and one would wonder why one needs an attorney if one was not charged and had not done anything wrong. Can you tell me what your reaction to that was as a father and also as an attorney of 30-some-odd years?
Well, as an attorney, I remember being taught that everyone had a constitutional right to a lawyer. And I noticed Mr. Nifong has lawyers, which he has the right to do. To me, it called into question. Here are 47 members of the team. The 3 who were residents had fully cooperated. The others wanted to talk with their parents. The parents wanted them to consult with lawyers before going down and talking with the district attorney, who had begun to malign the entire team. It seemed to me that it was a really, it was beyond what any prosecutor should ever say to make the players of the team look bad for seeking counsel when, under the circumstances, it was the appropriate thing to do and it was their right to do it.
You're aware that Mr. Cheshire made offers to have Dave come down and meet with Mr. Nifong, and that Mr. Nifong did not respond or take him up on that.
Could you speak up a little bit more, Mr. Brown?
I'm sorry. You're aware that Mr. Cheshire made offers to have your son come down and meet with Mr. Nifong, and that he did not take advantage of that. Can you?
Yes, Joe kept us very much involved in the defense. We were eager to try to share information with Mr. Nifong. We were eager for Joe to talk to Mr. Nifong, or with Dave's full statement to allow him to be questioned by Mr. Nifong. So we were hopeful that that would happen, and Mr. Cheshire indicated that we had photographs that proved that he didn't wear a mustache that night, and also produced a lie detector test from a highly respected individual showing that he passed in flying colors. So we were eager to try to talk to Mr. Nifong to head off an injustice.
What kind of effect has Mr. Nifong's misconduct had on your son?
No, let me say first that these statements came out and maligned an entire team. 47 players, their parents, their grandparents, their brothers and sisters, their schools were under attack by Mr. Nifong. Our entire world changed as a result of these unethical statements that were being made. With respect to Dave, still has to live with the fact that he was one of the captains and hosts of this party. And every day he feels terrible. The fact that his friends and teammates had to be drugged through this. Now, he didn't deserve it, carrying on a tradition of a party, but these statements tore a lot of people apart. Fortunately, our son Dave is very strong. He's very resilient. We're very proud of him. We're proud of the way he's handled this. And as I said to our daughter Kristen, who's been so great during this, and Ray and Dave, hopefully we won't be judged by whether we've had adversity. We'll be judged by how well we handled it. And I think our son has led the way in handling this outrageous situation well, looking out not only for himself, but for his teammates and his friends.
Did your son have a job offer at the time all this happened after graduation?
Yes, he did. The summer before his senior year, He worked on Wall Street. He worked at Merrill Lynch. At the end of the summer, he was made an offer from both Merrill Lynch and J.P. Morgan to join them. He selected J.P. Morgan.
Was that a difficult job to secure?
Well, the job was as a financial analyst in sales and trading, and it was probably one of the most coveted jobs that graduating seniors, economic majors, tried to secure. Hard to get.
And when did you find out that your son was going to be indicted?
We knew that Mr. Nifong was targeting our son, and we knew that in the end of April. We continued to hope that through cooperation, reason, and looking at the evidence that was coming out, that wouldn't happen. We actually went to baccalaureate at Duke Chapel. We came out. I called Brad Bannon to ask if we'd heard, and they were going to kind of put that off because they just didn't want to ruin things. So I gave Dave a bit of an answer, and he said, "I've got to know." And he called back Brad, and Brad said, "You're going to be indicted on Monday." So we, over that weekend, had that information. We knew what was going to happen. We knew that if Mr. Nifong or witnesses from the police department sought an indictment, that it would absolutely occur. We had a dinner Saturday night with all the senior players and their families, but couldn't really talk about it. On Sunday, Mother's Day, was graduation day. And so Dave graduated one day before he was indicted.
And what happened to the job at J.P. Morgan once he was indicted?
J.P. Morgan indicated that they had to withdraw the offer because of felony charges. Joe Cheshire talked with them and their human resources department in an effort to see if Dave could be given a job that didn't involve securities. And they indicated no, that would not be possible. And then we tried to determine whether, once the charges were brought, because we knew this was all a lie, we knew this was going to go away, whether or not he would be able to have the job waiting for him, and they said no. And in fact, that he would need to reapply. I am very happy, though, to report that I think it was April 12th, one day after Attorney General Roy Cooper pronounced Colin, Reed, and Dave innocent, that the head of investment banking for J.P. Morgan called Dave to renew the offer, but Dave had already accepted another offer.
Have there been continuing effects on your son and your family, even after the Attorney General's decision?
I can tell you that the answer is yes. I'm sure that the Finnertys, the Seligmans, and the Evans will tell you that it's not like turning off a switch. The emotion is still there. After listening to yesterday's testimony, I lost sleep again last night, hearing what I heard yesterday. I heard a number from the witness before. About a week and a half ago, I searched Yahoo, Dave Evans, Duke Lacrosse, 5,130,000 hits. I think it's going to be a while before that goes away. And Dave, in an interview, which there were very few, indicated that he believes that when he dies, that it will be reported, no matter what else he did during his life, that he was one of the 3 Duke lacrosse players who was accused of rape.
During this time period after the allegations broke, did you personally have any effects of that?
I thought I was pretty strong and unflappable. I began to lose weight, and also had a very difficult time sleeping. I mean, I can remember, if you have those digital clocks, looking at 2 o'clock, 3 o'clock in the morning, 4:30, worried every hour, thinking there's got to be something I can do to help my son. He's innocent. All we have to do is get that out. But of course, we learned we had to prove his innocence and Colin and Reed's innocence. I did find that I lost a lot of weight. I went and had it checked out and learned that I had type 1 diabetes. And we don't know exactly what caused that. I'm told that it probably was stress-induced. Type 1 diabetes is something you normally get when it's called juvenile diabetes. But if you're over 45, I'll be 62 this year. If you're over 45 and get to 50, it's uncommon. So it was either caused by stress or some viral infection, but I don't know about the viral infection, but I know I had a lot of stress. And it was for over a year.
Was your father-in-law, is your son named after your father-in-law?
Yes, my father-in-law, Ray's father, Raymond Anthony Forker, and David's middle name is Forker. Actually, the two look alike, although my father-in-law passed away. But we have a photo of Ray Forker, my father-in-law, when he was in the Navy, World War II, and he was about 23 years old. Dave's 24 now. Identical, look identical.
Did he take an interest in the lacrosse team?
89 years old. He followed it for 4 years. He loved it. You would see him with a Duke lacrosse hat, jacket, and shirt in a wheelchair because he had problems with his knees and his hips. He was loved by the players. He was adopted by the players. Every time he could, he would come to a game. There'd be a special place made for him, and he just loved the boys.
What happened when he became aware of what the allegations were and the charges against your son?
Very, very hard on him. He took it very, very hard. And he couldn't understand. He was consumed with the case. And, as it moved along, he would call several times a day to Dave, and they had a very good rapport, very proud of Dave's accomplishments. And he'd say, "Why is this district attorney going forward? Look at all this information. Look at this evidence. This accuser is not credible. What is going on?" Unfortunately, back on August 20, he died of a sudden heart attack. The great regret I know that Dave has, and Ray and I have, and Kristen, is that he died before he heard that the system worked and that Dave was declared innocent. We learned sometime after my father-in-law died that St. Raymond is the patron saint of the falsely accused. And we've embraced that. That's become very important to us. So we do feel that he knows, and we do feel that he had something to do with Dave and Reed and Colin, who were obviously falsely accused, for that truth to come out. And now we all wear the St. Raymond medal.
Did you hear Mr. Nifong's comments at this hearing directed at the families yesterday?
Yes, I did.
What was your reaction to it?
Mr. Nifong said it with great emotion. I can tell you that I did feel, and it resonated with me when Mr. Nifong said that he wanted his son to be proud of him. It particularly hit me since tomorrow is Father's Day. I would be less than candid if I didn't tell you how disappointed I was, and the Finnertys and the Seligmans, when asked by the chair whether he felt that a sexual assault had occurred, that he had a difficult time answering that, and then said that he thought something happened that night in that bathroom. I have a real hard time with that. I don't accept it. The Attorney General of North Carolina, Jim Coleman and Mary Winstead, for 90 days investigated this case, and what did they find? They found that the accuser was a liar with a mental health history. They found that the accuser, who I don't know, all day yesterday during Mr. Nifong's testimony, he referred to her as the victim. They are the victims, not Crystal Mangum. And he placed his career and reputation on a woman he didn't interview and persisted with this case, and then gave up the case because of a conflict of interest. And then the word of the Attorney General of North Carolina says they didn't do it. It didn't happen. She wasn't touched. She's a liar. She has a mental health record. And he says he still thinks something happened that night. Well, what that does is take me all the way back to late March of last year, where he began his unethical pretrial publicity that maligned every player on the Duke lacrosse team, their families, and their schools. I don't accept it. I'm just surprised he gave that answer, but he must have believed it. So I have a real hard time after that going much further into his apology.
Mr. Evans, I have no further questions.
No cross-examination. Thank you, Mr. Evans.
Place your left hand on the Bible and raise your right. Do you solemnly swear your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Please state your name, ma'am.
Mary Ellen Finnerty.
And are you Colin Finnerty's mother?
Yes, ma'am.
Do you have other children?
I do. We have 2 older children and 2 younger children. Colin has 2 older brothers and 2 younger sisters.
And are you married?
I am very happily married for almost 29 years now.
Please speak up just a little more.
Sorry. I've been married for 29 years. We've been married for 29 years.
And where do you live?
We live in Garden City, New York.
Would you tell the hearing committee about Colin?
Sure, I'd be pleased to. Colin is the third of our children. As I said, he has 2 older brothers. If I had to describe his personality and what makes him different from the rest of our children, I would say that he's probably the most private, shy in nature, although I think during this past year he's overcome some of that. And he's a good older brother to his younger sisters. He enjoys spending time with his 2 older brothers. He is a big boy with a big heart, very sensitive, religious, always enjoyed sports. From a young age, it was fairly clear to us that he had exceptional athletic abilities and loved anything to do with sports, not only lacrosse, it was basketball, tennis, swimming, anything. He always enjoyed being active. I think his dream was always, once he found lacrosse and settled on it as the sport of choice, I think it was his dream to attend Duke University and play lacrosse there. And he and we all were thrilled when that happened for him.
I'm going to take you now to the situation that's brought us here today. When this allegation of a sexual assault was unfolding in the media, what was that like for you as Colin's mother?
Extremely difficult. And I guess you're referring to pre-indictment.
At the beginning when you were just seeing these reports.
Right. Well, as Dave Evans said, knowing all the boys on the team, knowing them well, and it was devastating to hear the way they were falsely described in the media. It was hard to avoid. It was everywhere you turned, everywhere you looked. It was an incredibly difficult time for every Duke lacrosse parent.
At some point you learned that your son was going to actually be indicted. When was that?
Well, I guess it was Easter weekend, and Colin was home for Easter. He wasn't down in Durham. And I guess it sort of, we initially got the idea that he was what they called on a short list, that he was, hadn't been excluded by his attorney. We knew he was, possible, one of the boys to possibly be indicted, but we didn't know how long that list was. So I guess as the weekend progressed, by Easter Sunday, it became fairly clear that there were strong odds that Colin would be one of the boys to be indicted. We were advised by our attorneys to, at that point, leave our home in Garden City, not to be there. We knew it was a sealed indictment, and we didn't know what the manner of turning Colin in would be, so we didn't want it to happen in our home. We have other children there, so we left our home and went into a hotel in New York City. My husband, Colin, and myself, and Colin's girlfriend was with us for a good part of that time, and just sort of waited out Easter Sunday. And we didn't actually get the phone call till Monday morning when we knew.
What effect did it have on Colin when he found out that he had been chosen to be indicted in this case? I've been a parent for 26 years. And I have to say that it was by far and away the hardest moment of mothering that I've ever had. We found out, Colin and I were sitting in the hotel, and my husband was on the phone with one of our lawyers, and he was writing on a pad, Kevin, and the message, Colin and I were watching what he was writing, and the message pretty much was, there's a 90% chance that boys will be indicted. And if, in fact, they are indicted, Colin will be one. And then it was a short time after that, that was Monday morning, when our lawyer, who was at the Durham courthouse, called back and said, that it was Colin. He let out a cry that I'll never forget. He howled, and he just collapsed on the bed, and I just went to him and held him, and we all cried, but we knew that, I mean, we were blown away because it was just such a, how did this happen when, there was nothing to place, nothing had happened. There was nothing to place him there. We were blown away but nonetheless, we knew we had truth on our side, and we had to be resolute to fight. We were in the fight of our lives. We now had to fight to save our son's life. And from that day on, that was our job as parents.
What effect did the situation have on the other members of your family, Colin's sisters and brothers?
Well, you can imagine it was devastating. How do you explain to a 10-year-old that her brother had just been indicted for rape? How do you explain that crime alone to a 10-year-old? And his sister, at the time, was 16, and everybody was, overwhelmed with grief, but they just rallied to support their brother. I think the way we got through it was that we just stuck together as a family and did everything that we could to support him through this nightmare that we were all living at that time.
Where did Colin spend the spring and the summer and the fall of 2006?
Home.
At your home?
Yes, yeah.
And what did he do during the summer? Did he do the normal things that he would do during the summer?
No, I mean, our life was consumed with this, and many trips down to North Carolina, and he couldn't go anywhere or without being noticed, or it was an uncomfortable situation. Like I said, he's basically shy, so to be out in the public and constantly be, either elbows, like, there's that kid, or, and although the general support in our neighborhood was positive, it was still just hard. You couldn't do anything without being noticed or recognized. So most of his time was spent home.
Had Colin graduated from college when he was indicted?
No, he was just finishing up his sophomore year.
So were any efforts made to get Colin enrolled in college, in a different college?
He went to school in the fall and took one course at a local university.
Was there any effort to enroll him full-time in another university?
No, because we didn't know whether we were facing a trial or what lay ahead. So the idea of him going full-time anywhere else was impossible.
So did Colin miss a year of school
He
as
did.
a result of
He
this?
missed his whole junior year.
I'm going to go ahead and ask you to talk about the day in December when you learned that Mr. Nifong had concealed information that your son and his lawyer were entitled to, and had made misrepresentations to the court about that. But what was that like for you when you found that out?
It was extremely difficult to handle. I think I was one of the people in the courtroom who made the audible response that, it was shocking to know that all of this could have been avoided, to understand that exculpatory evidence had not been provided. Had Brad Bannon not done the amazing job that he did in the courtroom that day, many of us believe we still could be headed towards trial now.
When you were experiencing what happened last year and found that out on December the 15th, did you have any impression of what the justice system in North Carolina was like?
I didn't have a lot of confidence in it at that point, but I did have a tremendous amount of confidence in our legal teams, and the combined effort of all three legal teams gave me confidence that if we could physically and mentally go the distance, that they would in fact get the right outcome for us.
And that happened, didn't it? That eventually did happen after the Attorney General took over?
Yes.
Were you with your son the day that the Attorney General gave his press conference?
Oh, yeah. We were all together. All the families were together in a hotel room watching it, and it was an incredible moment for all of us. It was an answer to all our prayers for the last 14 months. I think it gave us all the resolution that we had prayed for.
Did it make everything okay?
Well, it certainly helped. Nobody can give any of the three families back the 14 months that we have gone through. The emotional pain, the physical pain, the fright of laying in bed at night and saying, my son and Reed and Dave could go to jail for 30 years for a crime that they didn't commit. That was frightening beyond. And then going forward, for all of us, I think that we'll forever be known as the Duke Lacrosse families. Our privacy will never be the same. And I think that goes for the three boys also. It's not something that will just go away. It will always be with all of us.
Has it had any effect that changed your son's personality? Is he different now?
I have to be honest with you and say that I'm amazed at how well he handled this. I think I learned from him through this. I never once saw him, lash out in anger or I think that he became a very strong person. I think he definitely grew up quickly. And I think it's made him aware of the huge issue that's out there of people being falsely accused. And I think that going forward, he truly hopes to play a role, as I think all the boys do, in trying to make sure that this doesn't happen. And if they know it's happening, they want to help.
Thank you, ma'am.
Thank you, Mrs. Finnerty. Any other? I apologize for the longer than anticipated delay. There was a matter that we needed to address with counsel in the case. We're now ready to proceed. I understand that Mr. Friedman, you would like to address the panel first.
Your Honor, Mr. Chairman, I've talked with Mr. Nifong, and he has told me, in light of the findings of fact that this commission has made, and he has told me that he believes this has been a fair and full hearing of the facts, that he believes that disbarment is the appropriate punishment in this case. And he also wishes me to advise that he waives all right of appeal from these proceedings.
Thank you, Mr. Friedman.
Thank you, Mr. Chairman.
In light of that, Ms. Jean, does the State Bar wish to present further argument on the matter of the appropriate discipline?
No, sir, Mr. Chairman. The State Bar agrees that disbarment is the correct discipline in this case.
Breaking news from
And
WRAL.
asks that an order of disbarment be entered.
This is David Crabtree in the TV5 newsroom. David Friedman, the attorney for Mike Nifong, just addressed this hearing of the State Bar and said that Mr. Nifong said that he felt the appropriate punishment for his actions in the Duke Lacrosse case was disbarment and that he would not appeal. Let's listen in.
About the criminal justice system in North Carolina, he hopes in his position this does help to restore at least some of the confidence in the criminal justice system in North Carolina.
Thank you, Mr. Friedman. Given that the State Bar rules do not provide that the defendant at this point is permitted simply to tender his license, the hearing committee must still deliberate and make a decision as to whether we are in fact satisfied under our standards that disbarment is the appropriate remedy. So we will do that at this time and come back to announce our decision no earlier than 5:15. So we will go deliberate at this point and come back by 5:15 or perhaps later. So we'll be in recess until then. Thank you for your patience. The hearing committee has deliberated, and we are in unanimous agreement that there is no discipline short of disbarment that would be appropriate in this case, given the magnitude of the offenses that we have found and the effect upon the profession and the public. I do want to make some remarks as to why we reached that conclusion. This matter has been a fiasco. There's no doubt about it. It has been a fiasco for a number of people, starting with the defendants and moving out from there to the justice system in general. We've heard evidence over the last several days of how that came about. And we are lawyers and a school administrator. We're not psychologists. But you have to ask yourself, why? Why did we get to the place that we got? It seems that at the root of it is self-deception arising out of self-interest. Mark Twain said that when a person cannot deceive himself, the chances are against his being able to deceive other people. And what we have here, it seems, is that we had a prosecutor who was faced with a very unusual situation in which the confluence of his self-interest collided with a very volatile mix of race, sex, and class, a situation that, if it were a plot of a John Grisham novel, would be considered to be perhaps too contrived. And at that time, he was facing a a primary. And yes, he was politically naive. But we can draw no other conclusion but that those initial statements that he made were to further his political ambitions. And having once done that, and having seen the facts as he hoped they would be, in his mind, the facts remained that way in the face of developing evidence that that was not in fact the case. And even today, one must say that in the face of a declaration of innocence by the Attorney General of North Carolina, it appears the defendant still believes the facts to be one way, and the world now knows that is not the case. We are required under our rules to consider certain aggravating and mitigating factors under Rule .0114W. And those are set forth in the rule, and I'm going to say what aggravating and mitigating factors we have found. We have found as aggravating factors dishonest or selfish motive, a pattern of misconduct, multiple offenses, refusal to acknowledge wrongful nature of conduct in the respect of the handling of the DNA evidence. We do find that he has made some acknowledgement of his wrongful conduct in regard to the pretrial statements. The vulnerability of the victim, or the victims in this case, and primarily the victims are the 3 young men who were wrongfully charged. And we find also as an aggravating factor substantial experience in the practice of law. As mitigating factors, we find absence of a prior disciplinary record and reputation for character. We expressly find that the aggravating factors outweigh the mitigating factors. This matter appears to be an aberration in a couple of respects. It appears to be an aberration in the life and career of Michael Nifong. It appears also to be an aberration in the way justice is handled in North Carolina. It's an illustration of the fact that character, good character, is not a constant. Character is dependent upon the situation. And probably any one of us could be faced with a situation at some point that would test our good character and we would prove wanting. And that has happened to Mike Nifong. But the fact that it has happened, and the fact that we have found dishonesty and deceitful conduct, requires us, in the interest of the protection of the public, to enter the most severe sanction that we can enter, which is disbarment. I want to say something about who the victims are here. The victims are the 3 young men to start with, their families, the entire lacrosse team and their coach, Duke University, the justice system in North Carolina and elsewhere, and indeed prosecutors, honest, ethical, hard-working prosecutors throughout the nation, as we've heard through anecdotal evidence, are victims of this conduct. And in particular, the justice system is a victim of the way this was taken out of, as Mr. Smith testified, taken out of the courtroom and put in the hands of the public. And not only the public in general, but into a media frenzy unprecedented in anyone's experience. As I think anyone who has sat through this entire proceeding, and we've been here now on the 5th day, knows that you can't do justice in the media, you can't do justice on sound bites. The way to arrive at a determination of the facts is to hear in a fair and open proceeding all of the evidence, and then for the trier of fact to determine what the facts are. And we've done that this week. That did not happen, and was not going to happen, apparently, in the Duke Lacrosse case. The justice system righted itself somehow so that at the end of the day there was indeed a declaration of innocence of these 3 young men. But it was done with backup systems in a way that was never designed to work as the justice system should work. Perhaps that was set in motion by the State Bar's initial complaint filed on December 28, 2006, that shortly thereafter led to the recusal of Mr. Nifong from the Duke Lacrosse cases. That was a controversial decision, I believe, certainly unprecedented that the State Bar would take disciplinary action against a prosecutor during the pendency of the case, when indeed the presiding judge had concurrent and coextensive disciplinary jurisdiction. That was a step, although we were not privy to the decision to do that. I am sure that was a matter of serious debate as to whether to do that, because that in itself took the justice system off track. The other mechanism by which the system more or less righted itself was the involvement of the Attorney General and the special prosecutors, who looked at it from the standpoint of prosecutors who were cognizant of their duty, the duty that was described here by Marcia Goodenow from the Mecklenburg County District Attorney's Office, and whom we found to be a very persuasive witness. And that led to something really very extraordinary, a declaration of actual innocence of the 3 defendants, something that could never have been accomplished even if the criminal case had proceeded before Judge Smith And while we don't know, it seems reasonably clear that one would predict that at the suppression hearing in February, the case would have been dismissed. But it would have been dismissed with no declaration of innocence. And indeed, this entire controversy regarding the wrongful prosecution still hanging over the heads of the defendants and of the justice system in North Carolina. So perhaps that was the good thing that happened, if one can find much of anything good out of this situation. But the fact that if these extraordinary circumstances had not come to pass, leading to that declaration of innocence, raises another point that we should all be aware of, which is that the person who is the most powerful in the criminal justice system is not the judge, and except at the end of the process, it's not the jury, it's the prosecutor who makes the charging decision to start with. The prosecutor, as any defense lawyer will tell you, is imbued with an aura that if he says it's so, it must be so. And even with all of the constitutional rights that are afforded criminal defendants, the prosecutor, merely by asserting a charge against defendants, already has a leg up. And when that power is abused, as it was here, it puts constitutional rights in jeopardy. We have a justice system, but the justice system only works if the people who participate in it are people of good faith and respect those rights. And Mr. Nifong, it must be said, for whatever reason, it does appear to us to be out of self-interest and self-deception, not necessarily out of an evil motive, but that his judgment was so clouded by his own self-interest that he lost sight of that and wandered off the path of justice, and it had to be put back on course again by, again, very extraordinary means. This is also a case where, due to the initial strong statements, unequivocal statements, made by Mr. Nifong, there was a deception perpetrated upon the public. And many people were made to look foolish because they simply accepted that if this prosecutor said it was true, it must be true. We all think back to those early days in the spring of last year, and you think of how public opinion was so overwhelmingly against these defendants. And you think of the public approbation that they suffered. And then you look as to how the truth came out slowly in small increments. And look at the situation now as to what public opinion is. It is a 180-degree turn. And those who made a rush to judgment based upon an unquestioning faith in what a prosecutor had told them were made to look foolish. And many still do look foolish. It is very difficult to find any good in this situation that brings us here. I can only think of a couple of things. One is that there are very few deterrents upon prosecutorial misconduct. For very good policy reasons, prosecutors are virtually immune from civil liability. About the worst that can happen to them in the conduct of the case is for the case to be overturned. The only significant deterrent upon a prosecutor is the possibility of disciplinary sanction. And here, the most severe sanction is warranted. I want to briefly address a matter that was actually included in Mr. Nifong's initial response to the State Bar grievance, which was to the effect that the word on the street was that the State Bar was out to get a prosecutor, inciting a couple of well-publicized cases in recent years involving prosecutors where it was widely perceived that there was insufficient discipline imposed. Now, I just want to step back for a moment and speak not as the chair of this panel, but as the chair of the Disciplinary Hearing Commission, and note that in those two cases, the situation was very different. Although you could look at it and say that the harm that was caused by the conduct was greater. In both of those cases, someone was actually wrongfully convicted of a capital crime. But in one of those cases, when it was prosecuted, there was no contention that there was any misconduct on behalf of the prosecutor that extended beyond gross negligence. In other words, there was no allegation or proof of intentional wrongdoing. And under the restrictions that we are under in the case of State Bar versus Talford, probably the maximum discipline that could be imposed was imposed. And indeed, under the particular provision, the same one that we are dealing with here, Rule 3.8D, as it was previously worded, the panel held that there was a non-delegable duty to know what's in your file, and that under the most jurisdictions, or the majority view, actually no discipline would be imposed. In the other case, which has recently been affirmed by the Court of Appeals, there was a dismissal based upon essentially the running of the limitations rule, and we did not address the merits. But we applied the rules. We applied the rules in both of those cases and reached, in my opinion, the correct result. And in this case, we have applied the rules, and again, we believe we have reached the correct result. and every case is different. But the case we have here is a clear case of intentional prosecutorial misconduct. So, in addition to this being a deterrent to any prosecutorial misconduct, I would say that this should be a reminder to everyone that it's the facts that matter. It's not the allegations. And that if you sit as a juror or if you sit at home watching your television about court proceedings, you have to carefully consider the facts and the evidence before you make a conclusion about something, and not just trust someone who tells you it is so, because that is someone in a position who is supposed to know. The other thing that may be good about this is to say this is another opportunity to acknowledge, based upon the actual testimony that we have heard over the last several days, and to remind everyone, other than the testimony of Brian Meehan on December 15, 2006, no one had given testimony in a public hearing under oath in this matter until this week. This has given an opportunity to air some, though not all, of the evidence that may relate to this matter. After all, our purpose is limited to the disciplinary matter before us and the specific allegations, and only involves the law license of Mike Nifong. But we've had an opportunity over the last several days to hear additional evidence. And while it is really not within the purview of the panel to make such a pronouncement, I want to say again that we acknowledge the actual innocence of the defendants, and there is nothing here that has done anything but support that assertion. Finally, I want it to be noted, and it may seem to be a subtle distinction, but it's an important one. It relates to this underlying case, which is, when this is reported, it should be noted not that the state bar disciplined Michael Nifong, but that the Disciplinary Hearing Commission of the North Carolina State Bar, particularly this panel of the Disciplinary Hearing Commission, disciplined Michael Nifong. That is important because it should illustrate to everyone that there has been a process here. The state bar, in secret, did not decide to take away the license of Michael Nifong to practice law. The state bar decided that they had evidence sufficient to go forward and seek to prove to an independent tribunal of triers of fact that his license should be taken away. And it took a long process culminating to this point in order to do that. And that's due process. And that's what was nearly hijacked in the case of the Duke Lacrosse defendants. that is about the only thing, those are the only things that come to mind that are good about this entire situation. It's been truly a fiasco is not too strong a word. But it could have resulted from a lapse of character of practically anyone, not just in particular Mike Nifong. We've heard anecdotal evidence of the harm that it has caused. The actual harm is very difficult for one to get one's arms around. But I certainly hope that this process will help assuage the harm and stop the ripples that seemed to start when the stone was thrown in the pond. They just got bigger and bigger. But hopefully they will ebb from this point forward. We expect to enter a written order in the near future. I won't put a timetable on it. It will take a little time. But again, that will be a final order, and I understand the defendant has waived his right to appeal it. So unless there's anything further for us to address, this proceeding is concluded. Thank you.